I'm going to show you two photos of former Prince Andrew. Prince Andrew attended various parties with Jeffrey Epstein. Under the law Congress passed, you were allowed to redact photos to protect the victims of Epstein's sex trafficking operation. You redacted the photos of this victim's face because you were following the congressional law. Is that correct?
When a law passes the House 427-1 and the Senate by unanimous consent, the outcome is usually certain. But in the winter of 2025, a nearly 4 million-page file became the center of a collision between a clear legal mandate and a Department of Justice that seemed determined to rewrite the rules of transparency. This isn't just about a list of names. It's about whether the standards of the American legal system apply to those at the very top. To stay informed on how these institutional shifts affect the rule of law, please subscribe and join the conversation in the comments below. Let's play this clip.
I'm sorry that we redacted the victim's
Because you were following the congressional law, correct?
Yes.
Okay. You have now established that please put the photos back up, that we are looking at a sex trafficking victim. Under the Federal Victims Trafficking Protection Act, not only is Jeffrey Epstein guilty, but anyone who patronizes Epstein's sex operation is also guilty of a crime. That's why I find it absolutely despicable that you sought to protect Epstein's clients, like former Prince Andrew. Last July, you closed the case on Epstein's abusers. The July 2025 memo from your Department of Justice stated, quote, "We did not uncover evidence that could predicate an investigation against uncharged third parties." These two photos, please put the photos back up. These two photos staring you in the face are evidence of a crime and more than enough evidence to predicate an investigation against former Prince Andrew. So I ask you, Attorney General Pam Bondi, why did you shut down this investigation last July, and why have you not prosecuted former Prince Andrew?
The scene inside the House Judiciary Committee room on February 11, 2026, was not merely a standard oversight hearing, it was a visible fracture in the traditional architecture of American justice. At the center of this fracture sat Attorney General Pam Bondi, the nation's chief law enforcement officer, facing questions about her department's handling of the Jeffrey Epstein investigation files. Behind her sat the survivors, the women who had lived through the crimes of a prolific sex trafficker and were now watching to see if the government they entrusted with their stories would finally hold his co-conspirators accountable. When Representative Pramila Jayapal asked these women to raise their hands if the Department of Justice had still not contacted them, every hand in the room went up. This moment served as a stark baseline for a larger discussion about how federal institutions are currently functioning under the pressure of political alignment and democratic norms. The most serious development in this ongoing narrative is the apparent disconnect between a direct legislative order and the executive branch's execution of that order. In November 2025, Congress passed the Epstein Files Transparency Act with overwhelming bipartisan support. The law was unambiguous. It required the Attorney General to release all unclassified documents related to the Epstein prosecution within 30 days. Yet, when the December 19th deadline arrived, the Department of Justice released only a partial trove of documents. Deputy Attorney General Todd Blanche informed the public that only several 100,000 files would be released initially, with more to follow in waves, a staggered rollout that legal scholars and lawmakers from both parties immediately flagged as a violation of the statute. This delay was not just a matter of administrative backlog, it followed a period of intense internal shifts within the administration's posture toward these files. Throughout early 2025, the administration had promised total transparency, with the president stating that 100% of all of these documents are being delivered. However, after a May 2025 briefing in which Attorney General Bondi informed the president that his own name appeared in the files, the public rhetoric shifted. The administration began to downplay the significance of the documents, eventually calling the files a hoax and suggesting that there was nothing of substance to disclose. This pivot raises fundamental questions about the independence of the Justice Department when its findings intersect with the personal interests of the executive. Let's play this clip.
I don't believe you asked Merrick Garland these questions when he was Attorney General and set before.
I agree with you.
You twice.
I've been claiming my time. I agree with you. I agree with you. During the Biden administration, I called for people looking at Epstein files. Merrick Garland dropped the ball, as did Attorney General Bill Barr, as did Alex Acosta, a whole string of failures. But you are in charge. You have the power to change things, to hold these men accountable, and you're doing the opposite. You're protecting them. So I want to move on to another man.
Can I answer
Donald
that,
Trump.
though?
I want to move on to another question.
Can I answer your question about protecting?
You answered the question.
You're saying no. I love this.
I want to discuss another man, Donald Trump, who is all over the Epstein files, like former Prince. Here's the video. Like former Prince Andrew, Donald Trump attended various parties with Jeffrey Epstein. I want to know, were there any underage girls at that party or at any party that Trump attended with Jeffrey Epstein?
The standard of the rule of law suggests that the law applies equally to all citizens regardless of their status, yet the rollout of the Epstein files revealed a pattern of selective redaction that many observers find deeply concerning. While the Department of Justice frequently blacked out the names of politically exposed persons and government officials, citing the need for review, it simultaneously failed to protect the identities of the victims. In the January 30th, 2026 release of 3.5 million pages, a review by the Wall Street Journal found that the names of 43 out of 47 victims were left unredacted. Even more troubling, the department included unredacted nude photographs of young women, some of whom may have been minors at the time the photos were taken. These survivors, who had been promised protection by the very law mandating the release, found themselves re-traumatized by a government agency that seemed more focused on redacting political names than protecting victim identities. During her testimony, Attorney General Bondi defended the department's actions by pointing to the volume of documents released, millions of pages. However, when pressed on the substance of those files, specifically why no new co-conspirators had been indicted, the Attorney General's responses moved away from legal reasoning and toward political deflection. At one point, when asked by Representative Jerry Nadler how many perpetrators were currently being investigated based on the new evidence, Bondi began shouting over the committee members, eventually citing the performance of the Dow Jones Industrial Average and the NASDAQ as evidence of the administration's success. The Dow is over $50,000. That's what we should be talking about, she insisted. This use of economic data to answer questions about criminal sex trafficking investigations represents a significant departure from the institutional standards expected of a sitting attorney general. The tension reached a boiling point when Representative Ted Lieu accused the Attorney General of lying under oath regarding the existence of evidence against Donald Trump. Bondi had asserted that there is no evidence that Donald Trump has committed a crime. Everyone knows that. In response, Lieu presented an FBI report containing a witness statement from a limo driver who claimed to have overheard Trump discussing the abuse of a girl with Jeffrey Epstein in 1995. The witness also alleged he met a girl who said she had been raped by both men. While these remain allegations in a case file rather than proven crimes, the Attorney General's categorical statement that no evidence existed was directly contradicted by the documents her own department was tasked with releasing. The institutional fallout from this handling of the Epstein files has not been limited to the halls of Congress. Across the globe, the revelations have forced the resignations of prominent figures in politics, business, and the arts. From the UK's Lord Mandelson to the Norwegian Prime Minister, the data contained in these files has acted as a catalyst for accountability in other nations. Domestically, however, the response from the Department of Justice has been marked by what critics describe as a weaponization of the legal system to target dissenters while shielding allies. Let's play this clip.
This is so ridiculous, and that they are trying to deflect from all the great things Donald Trump has done. There is no evidence that Donald Trump has committed a crime. Everyone knows that. This has been the most transparent presidency. He's the one that asked that those files
I'm reclaiming my time.
be released.
I got your answer. You said there's no evidence.
Trump asked
Mr. Chairman,
that
please
he
stop the clock.
signed
Stop the clock.
the legislation.
Time.
This is
Time.
this
I'd like
is
to reclaim my
ridiculous.
time.
Time belongs to the gentleman from California.
Okay. I'm going to put up another document from a witness who called the FBI's National Threat Operations Center because I believe you just lied under oath. There is ample evidence in the Epstein files.
Don't you ever accuse me of a crime.
I believe you just lied under oath, and this is all on videotape. You said there's no evidence of a crime. I'm showing you, here is a witness statement who called into the FBI's Threat Operations Center. He drove Donald Trump around in a limo. He overheard what Donald Trump said to Jeffrey on his cell phone. He was so angry, he was going to stop a limo and hurt Donald Trump. And he met a girl who said she was raped by Donald Trump and Jeffrey Epstein. She later had her head blown off, and officers at the scene said that could not have been suicide. No one at the Department of Justice interviewed this witness. You need to interview this witness immediately. Epstein should rot in hell, so should the men who patronized his operation. And as we sit here today, there are over 1,000 sex trafficking victims, and you have not held a single man accountable. Shame on you. If you had any decency, you would resign right after this hearing concludes.
The gentleman has expired.
May I respond?
Yeah, I don't know how you respond. No one can.
I did not ask a question, Ms.
He
Head.
doesn't
You're
want
allowed
to talk
to.
about
I did
the
not ask a
horrific
question.
crime in California. He does not want to talk about
I did not ask a question.
crime in his
She
state.
can't just
Madam Attorney
ad lib
General.
stuff. I did not ask a question.
Meeting will be in order. The gentleman is yielded back.
We see this pattern emerge in the attempted prosecution of 6 members of Congress, Representative Jason Crow, Senator Mark Kelly, and others, who had recorded a video urging troops to follow only legal orders. The Department of Justice sought to indict these lawmakers for sedition, a charge the president suggested should be punishable by death. When a federal grand jury refused to return an indictment, the lawmakers called it a win for the Constitution and an outrageous abuse of power. This attempt to use criminal prosecution as a tool to silence political speech is a primary example of how democratic norms can be eroded when the line between the executive branch and the Justice Department becomes blurred. Similarly, the Department of Justice pursued indictments against former FBI Director James Comey and New York Attorney General Letitia James, 2 figures who have historically challenged the president. These cases were eventually dismissed by a federal judge who found that the prosecutors had been unlawfully appointed. These documented actions suggest an institutional shift away from the impartial pursuit of justice and toward a system of political retribution. Even the Federal Bureau of Investigation has seen its standards for professional conduct called into question. Under Director Kash Patel, the Bureau has faced criticism for prematurely announcing updates in high-profile cases, such as the kidnapping of Nancy Guthrie. In that instance, a local delivery driver was detained at random, questioned for hours without his Miranda rights being read, and then released only after his name had been associated with a major crime. This force and bravado approach, as described by critics, has led to a pattern of investigative blunders that undermine public trust in the nation's premier law enforcement agency. The erosion of institutional standards is also visible in the administration's approach to economic policy and international relations. President Trump recently admitted that he raised tariffs on Switzerland from 30% to 39% because he didn't really like the way their leader spoke to him during an emergency phone call. He mistakenly referred to the Swiss leader, a member of their federal council, as the prime minister, and framed the tariff increase not as a strategic economic move, but as a personal response to her being very aggressive. This admission that national economic policy is being used as a tool for personal retribution aligns with the broader pattern of governance that prioritizes individual power over established diplomatic and institutional norms. In Michigan, the administration threatened to block the opening of the Gordie Howe International Bridge, a project already paid for by Canada, unless the U.S. was given at least half ownership. This threat reportedly followed a meeting between Commerce Secretary Howard Lutnick and a billionaire family that operates a competing bridge. While the administration framed the move as putting America first, critics pointed to it as another example of policy being dictated by the interests of wealthy allies rather than the rule of law or existing international agreements. Secretary Lutnick himself has faced calls to resign after the Epstein Files revealed that he had invited Epstein for a family dinner in 2012, years after Lutnick claimed he had severed all ties with the financier. Returning to the files themselves, the sheer volume of references to the president, over 1,000 mentions in the unredacted documents, according to Representative Jamie Raskin, paints a picture of long-standing social and business connections that the administration has consistently attempted to minimize. Documents from the 2026 release show that the president and Jeffrey Epstein were in contact as late as 2011, contradicting the president's public narrative that their relationship ended in 2006. Emails describe Epstein planning to call Trump in 2011 to discuss an individual named Virginia, and other files show the president was a passenger on Epstein's private jet at least 8 times between 1993 and 1996. While the administration argues that these mentions absolve the president of wrongdoing, the Department of Justice's own actions suggest a desire to conceal the extent of the connection. In one instance, the DOJ attempted to redact the president's face from a photo sent to Epstein by Steve Bannon, even though the president remained clearly identifiable. In another case, the department briefly removed a photo of the president and Epstein from its public website, restoring it only after a public outcry. These efforts to sanitize the files, a term used by Jeffrey Epstein's brother Mark, suggest an ongoing attempt to manage the political fallout of the disclosure rather than fulfilling the legal requirement for full transparency. The human cost of this institutional failure is perhaps best articulated by the survivors of Jeffrey Epstein's ring. In a collective statement, they noted that they are being named, scrutinized, and re-traumatized, while the enablers continue to benefit from secrecy. The Department of Justice's decision to release nude photos of these victims while redacting the names of powerful men is a vivid illustration of a system where the protection of power has seemingly taken precedence over the protection of the vulnerable. The response from Congress has been a mixture of outrage and a reassertion of constitutional authority. Representative Ro Khanna has read the names of men likely incriminated in the files on the House floor, using his congressional privilege to ensure the information reaches the public. Senator Cynthia Lummis, after viewing the unredacted files, remarked, "Now I see what the big deal is," validating the bipartisan push for the record's release. This cross-party momentum suggests that while the executive branch may attempt to slow walk or sanitize the truth, the legislative branch remains a critical check on that power. However, the question remains, what is the lasting impact on the institutions themselves? The mass exodus of career attorneys from the Civil Rights Division, the gutting of the section that prosecutes public corruption, and the firing of career prosecutors who worked on cases involving the president's interests all point toward a Department of Justice that is being fundamentally reshaped. When an attorney general yells at a member of Congress that she will answer the question the way I want to answer the question, it signals a shift in the very nature of government oversight. The rule of law is not just a collection of statutes, it is a set of shared norms and expectations about how power is exercised. It requires that an attorney general be more than a political advocate and that a Justice Department be more than an instrument of the executive's personal agenda. The story of the Epstein Files is the story of a law that was passed nearly unanimously by the people's representatives, yet was treated as a suggestion by those tasked with its enforcement. It is a story of victims who were promised justice, but were instead used as collateral in a political cover-up. As we look at the 3.5 million pages that have been released, and the millions more that Representative Khanna says are being withheld, the primary takeaway is not just the names of the individuals involved. It is the documented erosion of the standards that define the American democratic experiment. Whether it is the use of the FBI to detain innocent citizens, the use of tariffs to settle personal grievances, or the use of the Department of Justice to redact the names of the powerful while exposing the faces of their victims, the pattern is clear. The independence of the American legal system is designed to serve as a buffer against the whims of any single leader. When that buffer is removed, the result is the kind of volatility we saw in the El Paso airspace shutdown, an unprecedented ban on all flights over a major U.S. city that was announced for security reasons, and then abruptly lifted without explanation. It is the volatility of an administration that calls for the release of files one day and labels them a hoax the next, depending on whether its own interests are at stake. The survivors who stood in that hearing room on February 11th were not looking for political theatrics, a term the Attorney General used to dismiss their presence. They were looking for the basic functioning of a justice system that values the truth over the protection of politically exposed persons. The legacy of this period in American history will likely be defined by whether our institutions can survive this shift toward personalized power, or whether the rule of law will continue to be blacked out 119 pages at a time. The facts contained within the sources paint a picture of an administration struggling to reconcile its promises of transparency with the reality of what that transparency reveals. The president's name appearing more than 1 million times in the unredacted files is a fact. The failure of the DOJ to meet with survivors before releasing their names is a fact. The use of the Dow Jones average to deflect from questions about sex trafficking co-conspirators is a fact. These are not opinions or insults. They are the documented consequences of a specific approach to governing. In the end, the Epstein files may not lead to the immediate indictments that many in the public were hoping for, but they have already provided something else, a clear-eyed look at the current state of American justice. They have shown us a system where the law can be passed with 427 votes but still be treated as an obstacle to be managed rather than a mandate to be followed. They have shown us a Department of Justice that is increasingly viewed by its own employees and by the public as a tool of the executive branch rather than an independent arbiter of the law. This is the political albatross described by observers, a situation where the attempt to cover up or minimize the truth creates a crisis that far exceeds the original scandal. As the remaining files are reviewed by members of Congress in secure reading rooms, the battle for institutional integrity continues. The outcome of that battle will determine if the United States remains a nation governed by laws, or if the redaction pen has become the final word in American justice. The documented history of the Epstein Files Transparency Act, from its inception as a bipartisan push to its final messy execution, serves as a case study in the resilience and the fragility of democratic norms. It reminds us that transparency is not a gift given by the powerful, but a right demanded by the people and protected by the law. When that right is compromised, the entire structure of the government is weakened, leaving only the force and bravado of those in power to hold it together. As we move forward, the focus will remain on the unredacted files and the names that have yet to be spoken in the halls of Congress. But the larger story will always be about the survivors who raised their hands in a room full of people who were supposed to protect them and found that the government was still not ready to look them in the eye. That is the reality of the Epstein files, and that is the challenge facing the American rule of law today. The facts of the last year suggest that the traditions of the Department of Justice are being replaced by a new set of rules that prioritize the great things done by the president over the impartial investigation of evidence. It is a system where an attorney general can call a member of Congress a failed politician for demanding transparency, and where the economic boons for Main Street are used to justify the lack of accountability for those on Pedophile Island. This is the transformative period of American politics we are currently witnessing, documented not through speculation, but through the transcripts, memos, and files of the government itself. The data from the Bureau of Labor Statistics shows that job growth has slowed to nearly zero under the weight of new tariff policies, while the Department of Justice spends nearly $1 million on overtime to redact files that Congress ordered to be released. This contrast between the economic reality of many Americans and the administrative priorities of the government is a central theme of this era. It is a narrative of a government that is increasingly focused on its own survival and the protection of its leaders, even as the institutional standards that once guided it are being dismantled. In the coming months, the testimony of the Clintons before the House Oversight Committee and the continued reading of names by Representative Khanna will likely keep this issue in the public eye, but the real test will be whether the American public and its representatives can force a return to the norms of independence and accountability that have historically defined the Department of Justice. The Epstein files have provided the evidence. The question now is what the institutions of the United States will do with it. This isn't just about the past, it's about the precedent being set for the future. If a law as clear as the Epstein Files Transparency Act can be partially ignored and its intent subverted by the executive branch, then every law is subject to the same treatment. That is the fundamental concern for anyone evaluating U.S. political power today through the lens of democratic norms. The story of these files is still being written, but the chapters we have seen so far suggest a significant and documented shift in the way justice is administered in the United States. The millions of pages are there, the photos are there, the witness statements are there, and the names, appearing millions of times, are there. The only thing that remains to be seen is if the American system of government is still strong enough to follow those facts wherever they lead, or if the gutter of political theatrics will continue to be used as a shield against the truth. The standard has been set, the law has been signed, and the eyes of the survivors and the nation are watching.